Good morning, ladies and gentlemen. I am very happy you have accepted our invitation to take part in the conference entitled COFOLA. This abbreviation stands for Conference for Young Lawyers. This event has been held annually by the Faculty of Law at Masaryk University since 2007. I am very pleased that our event was supported by the Central European Professors Network, coordinated by the Ferenc Mádl Institute of Comparative Law in Budapest, Hungary. Unfortunately, probably due to the Zoom fatigue, this year we don't have many participants from abroad. I hope very much that our second event, the meeting we are going to hold in autumn, will be more international. So, without further ado, let's start with our topic, which is cohabitation in European context. Due to the considerable changes in Europe over the several few decades, the portrait of the family has been changing, which is, of course, reflected in the legal orders of different countries, as well as in the case law of the European Court of Human Rights. As mentioned earlier, our family law session is focused on cohabitation in the European context. During our conference, the attention will be paid not only to the Czech legal regulation anchored to the Civil Code, but to the principles on European family law regarding the property, maintenance and succession rights and duties of couples in de facto unions as created by the Commission on European Family Law. One of the contributions will be also dealing with the case law of the European Court of Human Rights. The title of my contribution is The Missing Concept of Cohabitation of De facto Couples of the Opposite Sex in De facto Unions in the Czech Civil Code. Let me start by briefly touching on some main turning points. I would like to draw your attention to the Charter of Fundamental Rights and Freedoms and the new Civil Code. The Charter of Fundamental Rights and Freedoms from 1991, as a part of the constitutional order of the Czech Republic, provides protection to the family as such without specifying it. New Civil Code, which was passed in the year of 2012 and has been effective since the year 2014, similarly to previous acts, regulates marriage not only for the people of the opposite sex. There is the Act on Registered Partnership as well, which regulates status relationship between the same-sex partners. It was passed in the year of 2006. For political reason, registered partnership was not included into new Civil Code, although it was planned and drawn by the main creators of the Civil Code. There is a pending draft on marriage for all at present. The question is whether there will be political will for passing it. Regarding de facto unions, there is no special regulation in the Czech legal order, and there are not relevant statistical data. The last census from 2011 showed quite a small number of people living in de facto cohabitation. However, there is another census being conducted at this very moment, which might bring to light some new highly relevant data. In general, it's difficult to rely on statistical data showing the proportions of children born out of marriage. There are a lot of them in the Czech Republic these days, almost 50%. But the chart you can see on the slide doesn't say anything about the parents of these children. Some of them have both legal parents, but some of them do not and live just with one of them, typical their mothers. It's interesting that during the communist times, former Czechoslovakia used to have quite a low rate of children born out of wedlock, and there were a lot of marriages. Cohabitation without marriage as a family model was used mainly by divorce or without people. However, living in cohabitation has become more popular than marriage among the youngest couples nowadays. As it was mentioned at the beginning, the portrait of family has been changing everywhere. the Czech Republic doesn't stay out of the European development. The question my colleagues and I pose to ourselves is whether the Czech Republic reflects these changes in family adequately and whether there should be more legal innovations in the future. Here you can see our research questions. Is Czech legal order regarding couples in de facto unions in harmony with the European standards? And what are the European standards regarding de facto unions? Is it a case law of the International Court of Human Rights on the Article 8 of the Convention? Are they the principles of European family law by the Commission on European family law? Is it a model family code by the academics? And does the Czech Civil Code meet the needs of the current society? Do we need an amendment to the Civil Code? And what does Czech family life look like? Before I speak about Czech family law, I would like to give you an information about principles and sources of inspiration for the new Czech Civil Code. Thanks to the main authors of the Czech Civil Code, the Czech Republic became more traditional again in this respect. Family law rules were enacted into the second book of the new Civil Code. That is why the concept of new family law is rather conservative. There are not many innovations. We can even say that couples living in de facto unions enjoy less standard of protection than in previous regulations. Here we can see the reason. It was published that the relationship between two persons of different sexes other than the marital relationship will not be institutionalized at present. It's clear that there is no demand for it in the present-day society. If it was established, it would be a new legal status, a second-order marriage. The main authors of the Czech Civil Code continued that marriage still has a very high credit in our country, and the situation of cohabitees will continue to be dealt with as it is today, namely by the concept of so-called persons sharing the same household, considered both in inheritance law and in housing rental law. In order to protect the weaker party, the creation of co-ownership of co-owners for things acquired during their cohabitation will be favored. Now I would like to draw your attention to the book 1 of the Czech Civil Code, general part. It was stressed in the introduction, the Civil Code expressly protects only the family established by marriage. There are two important sections in respect to cohabitees I would like to mention. First of all, there is a concept of close persons in this part, and there are three definitions of them. According to the Civil Code, a close person is a relative in the direct line, sibling and spouse, or a partner under the act of registered partnership. Other persons in a familiar or similar relationship shall, with regard to each other, be considered to be close persons if the harm suffered by one of them is perceived as his own harm by the other, and persons related by affinity and persons permanently living together are also presumed to be close persons. Secondly, I would like to mention new provisions regulating running of a limitation period. According to Civil Code, between spouses, a limitation period neither commences nor runs while the marriage lasts. It is applies by analogy to mutual rights of persons sharing the same household. These two concepts are relevant for the whole legal order. Regarding Book 2, Family Law, I would like to stress that due to the quite limited concept of family regulated in the Civil Code, there are no articles those would establish mutual rights and duties between the cohabitees. It means there is no duty to help each other, no community of property, no protection of family dwelling and of a common household goods, and no mutual maintenance duty by operation of law. Unfortunately, there are no often property contracts between the cohabitees, which causes a lot of problems for so-called weak party upon dissolution of the relationship de facto. However, there is no discrimination of children born out of wedlock, and the rights and duties of the parents of any child are equal. It should be mentioned that if an unmarried man and an unmarried woman have a child together, they both are principal holders of parental responsibility by operation of law without being discriminated against in comparison with married parents of a minor child. However, the parenthood must be legally established. There are no differences between the children at all, neither in personal nor property spheres in the Czech legal order. The law traditionally protects property claims of unmarried mother to the child. The Civil Code regulates maintenance and support and provisions for the payment of certain costs for an unmarried mother as follows. If the child's mother is not married to the child's father, the child's father shall provide her with maintenance for 2 years from the birth of the child and provide her with a reasonable contribution to cover the cost associated with pregnancy and childbirth. I would like to add that there is neither common adoption nor common foster care available for cohabitees. On the other hand, regarding law against domestic violence, anybody can seek the protection. Cohabitees are not excluded. Let's move to the book 3, Property Rights and Succession. As it was mentioned at the beginning, there is no community of property between people in de facto union and no protection of family dwelling and of a common household goods in comparison with married people. If people in de facto union acquire a property together, there can be only co-ownership with shares as between other people. Provided there is no agreed otherwise, the Civil Code states that the shares are equal. Regarding rights of a surviving cohabitee, his or her situation is in practice quite weak, as there is seldom a will or an inheritance contract. The rights of the surviving person are protected by the concept of persons sharing the same household. Anybody can be such a person. The Civil Code mentions persons sharing the same household in 2 provisions, regulating heirs of the second and of the third class. Cohabitee can be never an heir in the first class, where only a spouse and a child can inherit. If there is a child in cohabitation, he or she takes all. To summarize, the surviving cohabitee must prove many details from the common life during the succession proceedings, mainly duration of de facto unions, and so on. Besides, there is the concept of forced heir. According to the Civil Code, a forced heir include the decedent's children and, if they don't inherit, their descendants. If a forced heir is a minor, he must inherit at least 3/4 of his statutory inheritance share. If a forced heir is an adult, he must inherit at least 1/4 of his statutory inheritance share. And in addition, the law provides that the surviving pregnant cohabitee has right to limited maintenance from inheritance. The same rights has the mother of the decedent's child in postpartum period of 6 weeks. Let's concentrate on the book 4, Obligations. The new Civil Code recognizes the private autonomy, in particular the freedom to make contracts. The partners in de facto unions may make any agreements before and during the cohabitation and after the separation. There are almost no limits and no provisions for any authority to scrutinize the agreement. As I said before, unfortunately, there are seldom property contracts between the cohabitees, which causes a lot of problems for so-called weaker party upon dissolution of the relationship de facto. Regarding family dwelling, there are no special provisions which would protect the situation of surviving partner living in the rented flat by a leasee. The Civil Code provides consequences of the death of a leasee. It said that if a leasee dies and there is no joint lease of the apartment, the lease passes to a member of the leasee's household who live in the apartment on the day of the leasee's death and has no apartment of his own. If it's cohabitee, the lease passes to such a person only if the lessor consents to the passage of the lease to that person. Here I see a big problem and less protection than in previous regulations. I am going to conclude now. The people of the opposite sex can enter into marriage and enjoy the full catalogue of rights married couples are entitled to. People of the same sex can get registered and have some protection by law, especially in case of the death of one of the spouses. So the question we need to ask and answer are, is there a need for an amendment to the new Civil Code? Shall the lawmaker respect the private autonomy of the cohabitees willing not to have special rights and duties connected with marriage or registered partnership, or should the lawmaker draw special rules for them according to the Model Family Code or to the principles of European Family Law by the Commission on European Family Law, or should the lawmaker create different provisions? As there is almost no regulation of rights and duties of cohabitees, and there are seldom contracts between them, the situation of the weaker one is quite difficult. There is a lack of legal certainty, especially in families with minor children, when the union breaks down. However, it's difficult to strike a fair balance between the private autonomy of those who form a de facto union and between the protection of the welfare of family not based on marriage. I hope that during this conference, maybe in the discussion in other presentations as well, we will be able to address these questions in greater detail. That is all from me. Thank you very much for your attention. And now I am giving the floor to the next speaker, who is Mrs. Lucie Zadloukalová. Thank you very much.